Hi, this is Josh Blackman. I am the president of the Harlan Institute, and welcome to the Harlan Institute ConSource Virtual Supreme Court Competition. This year we are focusing on the case of Espinoza versus Montana Department of Revenue. Today we have a single match, which is Luke Spitzley from East Grand Rapids High School in Michigan, and he'll be representing the petitioner, Espinoza, in this case. Luke, whenever you're ready, you will have 15 minutes for your principal argument, and then you'll have 5 minutes for rebuttal. You may proceed.
Mr. Chief Justice, and may it please the court. This case asks whether or not it violates a religion clauses of the First Amendment for Montana to invalidate a generally available and religiously neutral student aid program simply because the program affords students the choice of attending religious schools. We emphatically hold that it does. Montana's Blaine Amendment violates this court's long-standing precedents by targeting and discriminating against religious use of generally available benefits. The Montana Blaine Amendment is in violation of this court's ruling in Trinity Lutheran by imposing an element of coercion on scholarship money. That decision held that any coercion forcing the Trinity Lutheran Church to choose between, quote, participating in an otherwise available benefit program or remaining a religious institution was, quote, odious to the Constitution, and the same is true of forcing Montanans to choose between sending their children to school and following the dictates of their faith. The decisions of Trinity Lutheran and Church of Lukumi also make clear that laws creating, quote, special disabilities on the basis of religion, religious views, or religious status, or that, quote, expressly discriminates against otherwise eligible recipients by disqualifying them from a public benefit solely because of their religious character, are unconstitutional violations of our free exercise rights. It is important to note that this case does not require a state to fund religious schools, but as Justice Scalia said in his Locke dissent, that, quote, when the state makes a public benefit generally available, that benefit becomes part of the baseline against which burdens on religion are measured, and when the state withholds that benefit from some individual solely on the basis of religion, it violates the free exercise clause no less than if it had imposed a special tax.
Well, Counselor, if I could interrupt briefly, you've talked a lot about the free exercise clause. I don't think you've mentioned the establishment clause yet. Isn't one of the concerns in this case the establishment clause that providing this money to a religious school would run afoul of the separation of church and state?
I do not think that is a central issue here because you have the element of private choice, which numerous decisions such as Salmon or Board of Education v. Mergen said decouple church and state. And in this instance, you have three levels of private choice. You have the private choice of the donors who decide whether or not to donate, the scholarship organizations who decide which at-need families to give that scholarship money to, and then lastly, you have the parents themselves, which can choose which schools they want to send their children to. And once you have that private choice, you can really use the money for the program for even very religious things. For example, in Locke v. Davey, while the court did say Washington could exclude the training of devotional theology, if it wanted to, it could have allowed for that scholarship money to go to devotional theology, and that would not violate the establishment clause.
So are you saying that the state can give money to a school and the school buys Bibles with that? That would be okay?
No, they can't give it directly to the school, but if it is funded to the school through the private choice of individuals who are a third party, then the issues of entanglement or indoctrination are not there in the same way.
But doesn't the state still have to decide which schools might be eligible for this in the first place?
Yes, they do, but those are general, like educational. They have to be on the baseline, and that's like a secular issue, and I don't think that is necessarily like a key issue here.
Well, let's move on to another question. We're not dealing here only with the federal establishment clause. We also have the so-called no aid provision, right, of the Montana Constitution. Can you tell me a little bit about that, please?
Yeah, Montana's Blaine Amendment was originally enacted in the late 19th century, following many other states who were following James G. Blaine, and there was anti-Catholic bias, and then it was reenacted in 1972. And when it was reenacted, there was many different reasons, but the same effect is there. The language was the same, and it prohibits any indirect or direct payment or appropriation to any sectarian institution.
Well, doesn't Article 10 of the Montana Constitution prohibit this program? Isn't this void under the Montana Constitution?
Yes, that is exactly right, and that is why we would take an as-applied challenge. You could challenge it facially, but we don't think that's necessary to resolve the case. And as applied, it is discriminating against people based on their status as being religious. And so we see it as in violation of the Free Exercise Clause and of the court's ruling in Trinity Lutheran.
So you're asking us to declare the Montana Constitution, Article 10, unconstitutional only in this context?
Yeah, I mean, it could be so egregious that you would need to facially rule it unconstitutional, but we don't think that's necessary.
Well, let's look at that for a second. Trinity Lutheran said you can't discriminate on the basis of religious status, right? That's I think more or less holding in Trinity Lutheran. When I look at the Blaine Amendment, it says no state aid for religious organizations. Isn't that exactly what Trinity Lutheran said you can't do? In other words, in what circumstance would the Blaine Amendment be constitutional under Trinity Lutheran? Can you think of an example?
Not off the top of my head, but I still think that unless it's absolutely necessary, we should take the more conservative approach and direct and as applied approach instead of facially striking down the entire Blaine Amendment.
Okay. All right. So let's move on a little bit. We've talked about Zellman v. Harris, Zellman versus Simmons Harris. We've talked about Trinity Lutheran. Let's talk about Locke v. Davey a little bit. How is this case distinguishable from Locke v. Davey?
Yeah, so first I'd like to point out that Locke v. Davey is definitely the exception to the rule. Across, there's 37 states that have these no-aid provisions. Many of them have had them for over 100 years. And the only time this court has held that a no-aid provision does not violate the Free Exercise Clause and the question of student aid was Locke v. Davey. And it only did so because the program went a long way towards including religion in its benefits. For example, the program allowed people to go to sectarian institutions and take religious classes. They only allowed for one specific exemption, which was devotional theology. There was a deeply rooted state interest in not funding the training of religious clergy. Whereas here the fact pattern is very different. It is just a blanket ban, and it does not foster any inclusivity for religious use at all.
All right. Well, let me ask you this question as well. There are about, I think, 30-something states that have these Blaine Amendments. They've been around for almost 100 years. If we declare the Montana one unconstitutional, at least in part, are all the other Blaine Amendments nationwide going to be in a similar position?
Not necessarily. I think the court should take it as a case-by-case basis because the language of each no-aid clause can actually have significant differences. For example, Utah has a no-aid provision and they only prohibit direct appropriations. They do not cover indirect appropriations or payments, which this case is largely focused on. So, for example, Utah's Blaine Amendment or no-aid provision wouldn't even be at issue in a case like this. So I think due to the fact that there is such a variety in some of the language of these no-aid provisions, they should be reviewed on a case-by-case basis.
Okay. Let's move on to history a little bit. We have a lot of very important writings from the founding era from people like Thomas Jefferson and James Madison that seem to recognize some of the risks of the state entangling itself. Let's start with the Madison's memorial remonstrance. How does that maybe help or hurt your position?
Yeah, I don't think Madison's remonstrance is particularly relevant to this, because the thing he was talking about was a special benefit for religion, a tax on Virginia to give money for the church, whereas here we are just asked to be treated equally as everybody else, to participate in a neutral, generally available benefit from the government. For example, I could hardly imagine Madison saying that any minister can't use the roads of the state because that could be entanglement. So I don't think it's necessarily a salient example for this, because we're talking
But I think let's just, if I can just interrupt you, I'm sorry. We're not just talking about using roads or maybe even using tire chips in the playground, right? The money given to the school can be used to purchase Bibles, right? It can be for explicitly religious things. Don't you see a difference between funding secular classes and funding purely religious study? There's no sort of a wall, so to speak, between how the money's being used.
I would say that the wall, again, comes in the form of private choice. Board of Education v. Mergens makes a very clear distinction in saying that if state money goes towards any religious like teaching, for example, that would violate the Establishment Clause. However, if that happens through private choice, that's protected by freedom of speech and free exercise of religion. And I would hold that private speech is really the important the thing that decouples the church and state and removes the
But don't we have a risk here that states can basically ignore the Establishment Clause by placing various intermediaries? Isn't that a risk that that creative legislators can sort of stack up intermediaries to avoid this sort of problem? Shouldn't we be worried about that?
I don't believe that we should, because like I said, there is 3 levels of private choice, so it's hard to imagine that the state is coordinating with the donors, the scholarship organizations, and the parents, and it is much, much more likely that these are individuals making their own private choices without any coercion on where to spend their money from the state.
Well, let me ask you this question. The Supreme Court has adopted various tests for the Establishment Clause over the last 30 or 40 years. Which test do you think is most relevant for us to consider today?
I think that Lukumi and Trinity Lutheran are the most important cases because they're talking about how whenever you have a generally available benefit, or at least in Trinity Lutheran, you just can't exclude religious use or.
Well, that's a good free exercise case. My question is a little bit different. I'm asking about what Establishment Clause case should we use?
Well, in Lemon, there is the primary purpose prong, where you can have the primary purpose to forward or inhibit religion. So I think that could be a useful test, although the Lemon test has definitely had its detractors over the year on the court.
Do you think the Lemon test is still good law? I mean, it has detractors, you say.
Yeah, I'd say it's definitely challengeable that Lemon is good law. I just don't find that in this court's body of jurisprudence on establishment that there's any cases that really challenge or would suggest that there's entanglement between the state in here. For example, in Witters, there was a unanimous decision that said that if there was private choice, that the state could even fund religious training due to the fact that there was private choice that decoupled the church and state entanglement.
All right, Counselor, you have about 30 seconds left. Do you want to wrap up?
Yeah, we ask you to reverse the ruling of the Montana Supreme Court and hold the exclusion of our plaintiffs due to their religious status as a violation of the Free Exercise Clause.
Okay, very good. All right, and you can begin right now if you want your 5 minutes of rebuttal time, or your fictional rebuttal time, but you can begin it.
Yeah, may it please the court. The respondents hold Committee for Public Education v. Nyquist as salient precedent with regards to this case. We disagree as we think this case presents little to no entanglement concerns because of the private choice which Zellman, Mergens, Locke, and many other cases say to couple church and state and remove any indoctrination or entanglement concerns. Also, the facts significantly differ to the type of benefit that is being given, as this is an indirect subsidy to a third party, whereas in Nyquist, it was a direct money grants from Chapter 414 to the schools, which requires a different analysis in the requirement of a primary secular purpose, which is not laden upon private individual choice. Indeed, going this far from the court's previous precedents would make it in violation of neutrality requirements from cases like Lemon, which require that state neither advances nor inhibits religion as part of its primary effect prong. The first portion of their argument talks about how states cannot fund. That was the end of my rebuttal arguments.
Okay, so let me try to simulate what I would usually say if we had the other team. I think Locke v. Davey might be a little bit tougher for you to distinguish away than you've done. I understand that we have these different layers of insulation, but Zellman, I think, clarified that there are certain things that money can't be spent on. Couldn't Montana restructure this program to say the money can't be spent on any religious studies? It has to be spent only on secular studies, like buying history books instead of Bibles. Wouldn't that be one possible way of remedying this issue?
No, I don't believe so, because the Blaine Amendment is pretty categorical in saying no aid can be given to any sectarian institutions. The Blaine Amendment, as written, gives no distinction between a primary secular or a secondary religious purpose, for example, to talk about Nyquist. So I think the Blaine Amendment is so broad that it wouldn't matter if the Montana legislature restructured the program. And that program would be very different, because that'd be giving aid directly to the schools, where this is giving indirect subsidy to a third party, and there's also elements of private choice.
Okay, well, let me ask you a bit of a trickier question if I can. What remedy should we do? I mean, what do you actually want this court to do?
I think they should strike down these applications to the Blaine Amendment, and I think the scholarship program should be put back as it was written, without the issuance of Rule 1 or without the Montana Supreme Court.
But let me just push you on that for a bit. Right now, no one gets the scholarship money, right? No one in the state gets it. How can we require Montana to reenact a policy that was itself discretionary? I mean, at the present moment, there are no free exercise violations. There are no Establishment Clause violations. Nothing is happening. The policy's gone. How can we reanimate a policy that was... I'm sorry, go ahead.
We would strongly disagree with that view, because if you look at a means-ends type of analysis, the end in both cases, Rule 1 and leveling down, was to make sure that the program worked with their Blaine Amendment. And they did that through different means, admittedly, but the same impermissible end was the goal. They used Rule 1 at first, and then they leveled down in the second application. And if you look at the Supreme Court with admittedly not in a completely analogous issue with the issue of race in Prince Edward County. After Brown v. Board of Education, they just closed their public school system because they didn't want to have to deal with immigration. However, the Supreme Court said even though they leveled it down for both Caucasian and African American citizens in their county, it still violated the Equal Protection Clause. And I think there are some lessons from that case that can be brought to this case, even though admittedly religion is different from the issue of race.
All right, and actually you have about 5 seconds left, so we'll wrap it up here. Thank you so much, Luke. That was fantastic, and it was extra difficult because you were all by yourself for 20 minutes straight. Most people have a partner they can pair off. That was excellent. I'm very proud of you, and also Mr. Horace, your student did a great job. Do you have any questions for me, Luke? Anything you want to ask either me or Sebastian?
Yeah, so we're gonna have, you said if I'm lucky enough to advance, we'll have another round.
That's what we're going to try and do. We're still figuring out the details sort of on the fly, but my goal is to have at least another set of rounds. So like our first round had 20 something teams. Maybe the next round will have 8 teams. I'm just making up numbers, but that's what I'm thinking at the moment. And then eventually we'll have a championship round of 2. But that's our ultimate goal because we have a lot of students who are scattered to the winds, and this is one way to maybe keep people engaged in this difficult time.
Yeah. My other question: do they know at all whether or not they're gonna cancel like the Constitution Day in New York? Because that's obviously in September.
Yeah. I mean, one of the prizes we announced was a trip to New York for the Constitution Day celebration. I cannot guarantee that will happen. I don't know. There's stuff going on at ConSource that's beyond my control. Sebastian, I don't think you have any plans, do you? Yet?
We don't know. We'll have to confer with our partners at iCivics.
Right. Yeah. I mean, so in the event that the dinner's canceled, we'll probably give like a cash prize equivalent, maybe like a gift card or something. You'll get something that we would have spent on your travel cost, but we just don't know what that is yet. I'm sorry.
And then this is just something I was curious when I was thinking about the case as a hypothetical question to ask you. With coercion, like an NFIB or South Dakota v. Dole, they were like talking about like at a certain point, the state doesn't have a choice, and then it becomes coercion on the federal government. Do you think that like, what if like 99% of Montana's private schools were religious schools? Like, at what point do you think it becomes that there's so many, or the percentage of religious schools is too high that it could just be seen as Montana funneling money to private schools because there's only private schools there?
Yeah, it's a good question. I wouldn't see that as a coercion issue. I'd see it as a pretext issue, right? Let's say they enacted a policy that on its face said any school can apply, but if 99% of the schools were religious in nature, you say, well, that's not really any school. You're trying to give it to the religious schools. It's almost like a pretextual argument. The coercion argument comes up in, you're a student sitting in a classroom and there's the teacher's leading a prayer, right? Do you feel coerced to join in? Or you're at a graduation ceremony and there's a rabbi giving a benediction, right?
Yeah.
Yeah.
I didn't mean coercion for like free exercise or establishment. I just was talking about that for fiscal federalism because it was the same like idea, like at a certain point or percentage.
Well, keep in mind that was also the federal government. The coercion doctrine applies to federal spending. I don't think the same doctrine would apply to state spending.
Yeah, exactly. I was just wondering because I think it's like 94% or something of Montana's private schools are religious.
Is that right? Okay. Oh, good point. Yeah, it's a good question.
All right, that's all my questions.
Thank you.
I just want to thank you guys, the teacher here. I just want to thank you guys so much for doing this and keeping kids engaged. It's just a challenge that we as teachers have had with online education, and so something like this is awesome. You're making education better. Thank you.
Thank you, and I'm grateful that teachers are trying to keep the ship moving forward. It's not easy, so we're doing the best we can. All right, everyone, I'll call this session to a close, and we'll be in touch in the next week or so. Thank you so much.
Thank you.